The Department of Education filed a motion on November the 6th requesting a temporary relief from a judgment. Now, the judgment that they're talking about, the judgment that they're referenced to, is the Sweet versus McMahon settlement. And it looks like they filed this motion on the 6th of November. And what they're asking the courts to do is to provide them with an extension, an 18-month extension for making decisions on applicants who are post-class members in this particular settlement. But I want to go over this motion because there's a lot of information that's in here, and it's extremely important if you are a post-class member in this settlement that you have an understanding of what is going on and what does that mean or could potentially mean for you going forward if the Department of Education was granted this extension. Also, if you are a post-class member in the settlement, the PPSL, so the Project on Predatory Student Lending, there were emails that were sent out to borrowers who are post-class members in the settlement. Not everyone got the email, but I'm going to provide you with the link so that way you can go and complete the survey if you did not get the email. But if you receive that email, what they're asking you to do is to complete this survey, and they give a deadline of the 18th of November. So that way they can see exactly because the survey is real cut, straightforward. It's just basically asking you information about your name, the school you attended, and how this extension, is harmful for you as a borrower. As of the 15th of November, so tomorrow, that means that majority of borrowers have been waiting on a decision on their application for at least 3 years. So you've already been waiting 3 years for a decision, and now the department is asking for borrowers to wait even longer. All right, let's go ahead and talk about the motion. So you can actually access this motion. You can get it from, hang on, let me show you. So basically what you can do is just go to the United States District Court, the Northern District of California, and basically just go under new file case documents. And this is where you'll see the new filings from 11/6 to 11/13. I just put in the word sweet, and this is where you were able to get the information. It's going to connect you to Pacer, so you have to have a Pacer account in order to access it. But you can also look on Reddit as well. There's a link that's being provided too, where you can view the information if you don't have access to Pacer. All right, so let's go back to the motion here and let's get started. So the first thing that we see here is the plaintiff and then also the defendants, the Department of Education. We're going to scroll down. It gives you the date that this motion is going to take place, to December 11th, 2025. And the time in the courtroom. So if you're someone that's in that San Francisco area, you can make it there. Definitely go ahead. If you can show up, but there's going to be a Zoom link as well if you can't make it in person. So let's keep going. All right. So this is where our table of contents are. We'll keep going. The different cases, the case law that's being used in this motion, the rules, regulations, and this is where we get into the actual motion within itself. Let me get my stuff out the way here because I like to keep notes so that way I stay on task. All right, so it tells us the notice of motion and motion for temporary relief from judgment. So this notice is hereby given that on December 11th at 8 a.m., they tell us before the Honorable Judge William Alsup, they give us the courtroom of the San Francisco courthouse. Defendants will move the court for relief pursuant to federal rules of Civil Procedure 60B. So when you see the first thing we know how they are actually, because I get asked the question, is this legal for the Department of Education to do this? What grounds are they using? What laws are they using? So it tells us right off the bat, they are using under or part of it is for relief pursuant to Federal Rule of Civil Procedure 60B. So we have to know, what exactly does Federal Rule of 60B state? What does it state there that gives them the grounds to be able to utilize it? So basically what you can just do is go to Google and type in Federal Rule of Civil Procedure 60B. And this is where we get Rule 60, relief from a judgment or order. And let's read through it because they are using, as we see in the motion, they're using 60B. So we're going to we're in Rule 60, we see A here, and we're going to go to B. Grounds for relief from a final judgment order or proceeding. On motion and just terms, the court may relieve a party or its legal representative from a final judgment order or proceeding for the following reasons: mistake, inadvertent, surprise, or excusable neglect, newly discovered evidence that with reasonable diligence could not have been discovered in time to move for a new trial, fraud, the judgment is valid, the judgment has been satisfied, released, or discharged, it is based on an earlier judgment that has been reversed or vacated, or applying this prospectively is no longer equitable. And this is something that we're going to see in this motion, okay? This is what their claims is. It is no longer equitable or any other reasons that justifies relief. All right, so we know what Federal Rules of Civil Procedure 60B what it speaks about and what grounds it is that they are seeking relief under temporarily as they claim from this judgment. All right, let's go back to the motion. All right, so it says defendants, which is the Department of Education, seeks temporary relief from the provisions of the parties' settlement agreement as incorporated in the court's final judgment, and they give us the file case number that requires defendants to provide full settlement relief to certain non-class members if defendants fail to issue timely final decisions on such non-class members' borrows defense applications by January 28, 2026. So if you are a post-class member in the settlement, meaning that you put your application anywhere between June 22nd, 2022, or by August 15th, 2022, that will make you a post-class member in this settlement. If the Department of Education did not make a decision on your application, they did not adjudicate the application by the 28th of January, 2026, then you were entitled to full debt relief and refund of payments that were made. So this is what they're requesting this extension on, giving them more time to make decisions on these applications, which literally they had 2 months, a little over 2 months, that borrowers would have been, potentially debt-free if the Department of Education, now we have this motion, but nothing has been agreed upon yet. Defendants respectfully request that the deadline for providing final decisions to these non-class members be extended by 18 months until July 28th, 2027, at which point defendants' obligation to provide full settlement relief to any non-class members whose applications are undecided by that date will be reinstated. The basis for the motion is set forth in the following memorandum of points and authorities. All right, so let's get down to what the memorandum of points and authorities, what they are talking about. And this is basically where we get into the facts and whatever their evidence and all those things, what their argument is, okay? So it tells us in June 2022, the Department of Education and the plaintiffs reached a settlement agreement that provided a comprehensive framework for resolving hundreds of thousands of pending borrow defense applications, some of which have been pending for more than 7 years. The court approved that agreement, finding it to be a grand slam home run for class members, and retained jurisdiction to oversee the settlement's implementation. In the 3 years since, the settlement agreement has provided a reasonable and equitable resolution of class members' claims, and the department has substantially complied with all of its obligations to class members, which, I can't say that they substantially complied, but because there was a motion to enforce the settlement because they were not. Okay, let me keep going because I'll go left, okay? However, obligations to one group of individuals addressed in the settlement, the post class, consisting of certain individuals who had not submitted borrower's defense applications at the time the parties executed their agreement, remain outstanding. The settlement requires the department to adjudicate all claims submitted by this set of post class applicants by January 28, 2026, or else provide them full settlement relief, including discharging relevant student loan debt, refunding amounts paid to the department toward those loans, and facilitating corresponding credit reporting reliefs. So this is what post-class members will be entitled to. If the department does not adjudicate, make a decision on their claims on those applications by the 28th of January, 2026, then that is where that full settlement relief comes into play, refunding of any amounts paid, and then also getting the information off the credit reports. But things have changed. This is where we get into the argument. But things have changed, and due to a variety of circumstances, including most notably the unanticipated size of the post-class pool, the department's reasonable but unexpected resource constraints, and the new requirement in certain circumstances that the department now discharge ineligible loan debt unrelated to a post-class applicant's borrow defense application. The court should provide the department relief from this one aspect of the party's comprehensive and otherwise nearly concluded settlement agreement. They go into Federal Rules of Civil Procedure 60b-5, which we looked at, provides a court discretion to relieve a party or its legal representative from a final judgment order of proceeding if applying it prospectively is no longer equitable. This standard is met with respect to the requirement that the department provide full settlement relief on any post-class borrow defense application that remains unadjudicated as of January 28, 2026. To start, the court has jurisdiction to provide relief because it approved the agreement, incorporated into a final judgment, and retained jurisdiction over the matter. The agreement is thus subject to modification, the same as any other final judgment or order. And relief is appropriate here because the size of the post class, comprising 207,000 applicants who submitted more than 251,000 applications in less than 5-month period from June 23rd, 2022, the day after the settlement was executed, to November 15th, 2022, the day before it received final court approval, is an order of magnitude greater than anything the department could have reasonably expected when it entered into the settlement. First and foremost, I want to say, let's go. I love to see those amount of numbers. I remember trying to go back to back to get people to get borrowers to put in their applications. I love to see those numbers. It's unfortunate that we are here today, but I can't say that we didn't expect this with the Department of Education with these applications. But let's keep going, okay? Indeed, the post-class pool of applications exceeds by more than 200,000 the number of applications that were submitted in any comparable 5-month period before or after the agreement was executed, and rivals the total number of borrower defense applications that were pending at the time the settlement was executed. Moreover, the department has not received the resources that are needed to adjudicate post-class applications. Now, mind you, we know the Department of Education, if you've been keeping up, the administration, they have cut their own staff. I mean, not only that, they have tried to dismantle, or they actively are trying to dismantle the Department of Education. So these are things that they have done to themselves, and want student loan borrowers to feel sympathy for them. But let's keep going. Congress repeatedly ignored requests for funding to increase staffing to the levels the department deemed necessary